The cases we're going to talk about today are all either Appellate Division, New Jersey Supreme Court, or United States Supreme Court cases. There's one Law Division case, and again, we have it in here. In fact, I'm going to ask you to talk about that one because it has a particular utility in crime fighting, especially in drunk driving prosecutions. Okay? So that having been said, here we go. And the first case is State versus Gant. Interesting 5-4 decision written by Justice Stevens, and you know the old saying in sports, it's better to be lucky than good. You stop to think about this. The police, this is a case where the police conducted a search incident to an arrest, and in the search they found drugs, which should be no surprise, okay? If the police had just found the drugs, this case never would have gone to the Supreme Court. Now the police, in part of their search, also found a pistol, okay? And if they had just found the pistol, it would never would have gone to the Supreme Court. But here's where we got lucky. The fact that they found a gun and drugs, that's what made it a federal case, and that's why it went to the United States Supreme Court. Gant is going to be the federal equivalent of State versus Eckel. So when you're going to kind of think about this in your mind, this is a response to the Supreme Court of a lot of criticism that's come up over the years, very little of which is mentioned in the decision, although they acknowledge that their decision in Belton versus New York had been subject to a lot of criticism in the case law and also by legal scholars. I think the best explanation of all the criticism of the Belton decision is set forth in State versus Eckel. Our New Jersey Supreme Court kind of goes through all the criticism that had taken place over that rule. Belton, as you remember, is the 1981 case where the Supreme Court held that when the police arrest an occupant of a motor vehicle, they can conduct a search incident to the arrest of the motor vehicle in order to recover all the same things you'd look for in a Chamel case, you know, weapons, implements of escape, fruits and instrumentalities of crime. And that's the type of thing you would go into. And I think it was just generally kind of interpreted that this is a kind of an open search, and the police can just search inside the vehicle and inside any containers in the vehicle to recover those items. The New Jersey, where we kind of parted company under our state constitution, was that it really didn't bring anything to the table. It became unreasonable when the defendant is in handcuffs in the back of a police car. He doesn't really pose any type of threat to the officer in terms of being able to grab a weapon from inside the vehicle, nor is he able to secrete or destroy any evidence or grab any implements of escape while he's in custody. So our Supreme Court, interpreting first the Appellate Division, then our Supreme Court, departed company from the United States Supreme Court under Article 1, Paragraph 7 of our state constitution, and made a determination that we would take a different path and that Belton would not be part of the law of our state. It's kind of funny the attitude the Supreme Court has toward this entire controversy. It's almost like they're saying, well, we never meant to say that you could search the whole car. You know, you guys misinterpreted it for the last 25 or 26 years. They're kind of like trying to duck some of the responsibility for this wide open authority it gave police officers to do this. But the case basically stands for the proposition that the ability of the police to conduct a search of a motor vehicle after the arrest of an occupant, incident to that arrest, should not occur when the defendant has been placed in handcuffs and put in the back of a police car. There's no necessity to do it. It makes the search unreasonable. So, I mean, in that sense, New Jersey's way ahead of the curve, and the rest of the United States policing is going to have to catch up because we've already, I think law enforcement has already adjusted to what we have to do now in those situations because of the Eckel case. We have a head start on everybody else, and now the rest of the country that didn't have Eckel built into their state law is going to have to catch up to us. But there's something very interesting in the case, and I think it bodes well for New Jersey police and for you as an appellate advocate. It's not as simple as just saying, okay, the police have secured someone, put them inside the vehicle, and they can't search the vehicle. That's fine, but the Supreme Court of the United States gives an alternative way that the police can still go into a vehicle and conduct a search when they've arrested someone, an occupant of the vehicle, and search incident to the arrest. Remember now, in this particular case, they arrested this guy for driving on the revoked list, so the likelihood of him finding evidence of driving on the revoked list inside the car is 0, okay? However, tell them about the alternative.
Well, the alternative is that, in the opinion, the court says that if even if the defendant is locked up, if the police are looking for evidence that is directly related to what the defendant has been arrested for, they may still be able to go back into the car, even though the defendant is already incapacitated, and look for that. And that's different from what Eckel seems to say, that you can't go back at all.
So my advice to those of you who are advocates, not that there's anybody who would ever go to the appellate division with this type of stuff, is that this may provide you with an opportunity to ask for a reinterpretation or relaxation. I think reinterpretation is probably the better rule to use in the appellate division or in the New Jersey Supreme Court on Eckel, and say that it would be reasonable for the police to conduct a search, incident, and arrest to recover evidence that might be associated with the crime for which the defendant would be arrested, like drugs or something of that nature. That search would be reasonable both, it's certainly, the Supreme Court says it's reasonable under the Fourth Amendment. The argument you'd make is that search would be reasonable under Article 1, Paragraph 7 of the state constitution as well, and you have ample precedent. Now, I'm not suggesting for one second that's the law of our state at this point, but what I am suggesting, if you're a prosecutor and you have the appropriate case where these facts work out, this is something you should be pitching to the appellate division or the Supreme Court, okay? Now, Johnny, could you just read the beginning part here?
We reject this reading of Belton and hold that the Schimmel rationale authorizes police to search a vehicle incident to a recent occupant's arrest only when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search. It is particularly significant that Belton searches authorize police officers to search not just the passenger compartment, but every purse, briefcase, or other container within that space. A rule that gives police the power to conduct such a search whenever an individual is caught committing a traffic offense when there is no basis for believing evidence of the offense might be found in the vehicle, creates a serious and recurring threat to the privacy of countless individuals. Indeed, the character of that threat implicates the central concern underlying the Fourth Amendment, the concern about giving police officers unbridled discretion to rummage at will among a person's private effects.
Of course, there was nothing in Belton to suggest that the police couldn't do that. But, you know, times have changed, I guess. The key language is what Bill pointed out to you. Please circle that. And again, if you have an advocate, if you're going to be advocating, you know, the or language there is giving you this alternative basis. All right? Okay, onward. You know, all of the State versus Johnsons in New Jersey. You know, he went out to Arizona and got in trouble out there.
One more thing for the police about Belton. Notice that Arizona versus Gant does not overrule Belton, which means Belton is still good law in circumstances where it's legitimate to use it. So, for instance, as a theoretical matter, if you arrest the defendant while he's sitting in the driver's seat of the car, and you leave the defendant sitting in the driver's seat of the car, Belton will still allow you to search the passenger compartment of the vehicle and any containers found therein. Similarly, as the language of that paragraph that we were talking about a minute ago suggests, if you arrest the defendant immediately outside the car, by the door, for instance, and you leave the defendant unsecured by the door, Belton/Schimmel would allow you to search the interior of the car. The problem is, of course, that that's horrible police procedure because you don't want to allow this unsecured defendant to sit there or to stand there posing risks to you while you're searching the car. So it's not a wise thing to do, but again, from a theoretical perspective, it's at least important to understand that Belton would allow you still, and Eckel would allow you still, to conduct that search as long as the defendant is not secured and away from the vehicle, because that's the key to the Eckel and to the limitation now on Belton by Arizona versus Gant.